I'm Lawyer Alexandria Sarah, and this is Lawyer Talk Thursday. And COVID has all of us thinking about what would happen if something bad happened to us. Where would our property go? What would happen to our family? So today we're going to talk about estate planning. Estate planning is this broad term for what happens to your property and your family if you die. So there's a lot to estate planning, but I'm going to cover three main things: wills, non-probate property, and power of attorney. So let's get into it. There's tons of definitions that I'm going to have to cover, and they're going to sound a little ridiculous because the law, But if you're confused about anything or have additional questions, just drop me a DM or call my office and we can set up a Zoom consult. So your estate means your real and your personal property that you own, right, that should pass to somebody on your death. Now, real property are things like land, mineral and oil rights, or anything that's on the land like improvements. So barns, garages, houses, all that good stuff. Your personal property is literally everything else: jewelry, family heirlooms, paintings, clothing, automobiles, motorcycles, even your fur babies. Those are personal property. So it's super important to decide who gets the rights to that property when you pass. Okay, so there's literally two ways we do this. You die with a will or you die without a will. So with a will, you get to decide where your stuff goes and who has guardianship rights of your minor children. If you die without a will, you're not so lucky. And the laws of Texas through the courts are going to decide who gets your stuff. Now, first, let's talk about the situation that we don't want at all. We don't want you passing without a will because it's super, super risky. Now, the law in Texas for probate says that your heirs at law, which are generally your relatives by blood or marriage. Now, there's no consideration of whether your son or daughter is crappy and will squander all your money, whether they even like you, whether they're good people, whether they've seen you in 50 years, right? Your heirs at law are your heirs at law. But with a will, you can give your stuff to whoever you want. Now I'll give you some examples of things that have actually happened, not just in the movies. So let's say your mom passes, you're one of two siblings, you guys are talking about splitting up what the property is, right? No will. And then all of a sudden, long lost half brother that you've never met in your life and she never told you about comes into the picture. Guess who gets part of that estate? That person that you've never met in your life. Like, this stuff doesn't just happen in the movies. There's actual cases where this happens. A second example is, let's say you're a second wife and you have a couple of kids with your spouse, and the plan is if he passes, you get all the money and property so you can take care of your minor children. Cool, right? But then he doesn't put that in writing and doesn't have a will. Now, first wife and him had a couple kids as well. If he dies without a will, your kids and you are not going to get everything. Those kiddos over here are going to get some too. So you have less money to take care of your children, even though it was his intent to do so. So that's another important reason to have a will. Now, the third is, let's say you have a person that you care about that's not your heir at law. A mentor, an educator, a student, a caretaker, whatever, right? Those people aren't heirs. So if you don't have a will, they get nothing. And like me, unmarried, no kiddos, my godchildren get nothing. So I have a will that leaves everything to my godchildren. Otherwise, they wouldn't get anything. Same thing as you have stepchildren. Unless they've been adopted, stepchildren get nada. So it's so important that you have that documented. So what does a will do? Well, you should know by now it passes property and determines rights to your children, or to guardianship of your children. Okay, Texas recognizes both handwritten wills and formal wills. So formal wills are your typed wills. You get them through an attorney usually. A handwritten will is called a holographic will. And for both of them, you have to be 18 years or older, in the military, or legally married, and you have to be of sound mind, not forced or deceived into signing this will, And also you have to have the intent to give away the property, okay? Usually that's satisfied by saying, this is my last will and testament. Now, the person that makes the will is called a testator. Yes, I'm only gonna say that one time, okay? So you, as that person, have to sign the will. For handwritten wills, it needs to be totally in your writing and say that phrase, this is my last will and testament. Doesn't matter what it's written on, your stationery, a piece of paper, a napkin, whatever. But the problem with holographic or handwritten wills is maybe you don't know what property you can give away, or you give away too much or too little property. That may end up in probate anyway. Or you identify somebody to manage that property, or an executor or executrix, right, if it's a female, but you don't say without court supervision or without bond. All of those things are going to give you problems once this will is actually in play after your death. So my recommendation is find a good attorney to help you do a will. Simple wills are easy, super fast, and actually pretty cheap to do. So your typewritten will, your formal will, that's something that an attorney prepares. They'll prepare it for you based on all your assets and all your wishes. You sign it, and you have 2 witnesses over the age of 14 sign it as well. Simple as that. Now, can you change your will? Abso-freaking-lutely. And if you learn nothing in this LTT is review those things periodically. Every couple of years, every time you get married, divorced, have another kiddo, change jobs. Because so many people neglect to do that and end up with people that they don't really like getting their stuff on death. Maybe you don't care because you're gone, but I bet you your family cares. So review this stuff periodically. Same thing with non-probate assets. So that's what we're going to talk about next, okay? Non-probate property. Those are things that pass by contract or survivorship. Survivorship is a theme for another LTT. But for contract, we're talking about things like life insurance benefits, IRAs, 401ks, pension, employee benefits, things like that. If you've ever had a job or been offered those type of benefits, you have to sign a form, a beneficiary form. And what a beneficiary is someone who's going to get that cash or property when you pass. Okay, again, if you learn nothing, change these forms periodically. Because I don't know how many times we've got ex-wife's name on a beneficiary form. Do you want your ex-wife getting $100,000 in life insurance when you die? I didn't think so. So look at this stuff often and change it. And sometimes clients don't even know that they have these assets or forget about, I've got $5,000 in a retirement account from a job that I had 10 years ago and I didn't roll it over. So you need to collect this information and constantly be reviewing it so that your wishes are what happens upon your death. Now, finally, let's talk about powers of attorney. Now, there's a lot to talk about in this area as well, but I'm going to cover 2. One is a medical power of attorney, and the second is a durable power of attorney. So these powers of attorneys are typically for when you're incapacitated. You're in a coma, you can't make medical decisions, you are in surgery and something happens and a doctor needs to know what to do, what your wishes are, those kind of things. So a medical power of attorney gives someone the right to make healthcare decisions or medical decisions for you if you're incapacitated. Okay? A durable power of attorney that goes into effect when you're incapacitated gives somebody the decision-making authority over your property, bank accounts, real estate, things like that. Those 2 are not the same thing. So if you give somebody a durable power of attorney that doesn't include medical power of attorney, then they can't make your medical decisions, okay? Same thing, you give somebody a medical power of attorney, but don't give them the right to handle your bank accounts, your bills, your real estate, what have you, that's a problem. So be mindful of that if you want to issue a power of attorney. You could also give power of attorneys when you're not incapacitated. I've done several for families who have people who are incarcerated, that need to file taxes, that need to sell cars, things like that. So power of attorneys are great to have, especially medical power of attorney, because anything can happen at any time. So that's all for today on LTT. If you have any questions about any of these things or other things involved in estate planning, hit me up and I'm happy to answer your questions.